My Lord, I'm so sorry. Before my learned friend starts, I was just told, just a timing point, that we've been told that the transcribers this morning would like a 5-minute break at the midpoint this morning.
Well, that can coincide with what I was suggesting.
Indeed.
There will be a break anyway. So
I'd
that is what
forgotten.
we will do. How have you agreed the time between yourselves? Perhaps Mr. Chivers can explain.
Perhaps.
My Lord, I propose to be no more than 45 minutes this morning. That should give my learned friend 3.5 hours run and leave me 45 minutes at the end. That would have given us equal time overall.
Excellent. Thank you very much. Yes.
Lord Hodge asked yesterday whether there were provisions in the Act for capital maintenance and reduction of capital. We've provided the Act electronically, so you can see those provisions.
They're there, yes.
And the short answer is there are capital maintenance provisions, and that under Section 44, which we don't need to go to, reductions of capital can be effected subject to special resolution and a solvency test. My Lords also asked whether there were any provisions for online voting in the Act. The answer is there are not. And I just draw your Lordship's attentions to sections 114 and 117, which deal with voting at meetings.
And sorry, page.
This is in the...
This is the new document.
Oh, the new text, right.
Yes, 114. So
114.
that will be...
It's page 52 of
52 of 194.
the document.
Yep.
So you'll see that 1141, unless the articles otherwise provided, don't. On a show of hands, the shareholder or proxy holder has one vote. On a poll, the shareholder or proxy holder has one vote for every share held. And then you'll see at 1142 that the proxy holder has the same rights as the shareholder who appointed him to speak and vote at the meeting, both on a show of hands and a proxy. And then 117, voting method of meetings, unless the bylaws otherwise provide, and again they don't. Voting at a meeting shareholder must be by a show of hands, except where a ballot is demanded by the shareholder or proxy holder entitled to vote at the meeting. So you've clearly got to be at the meeting to vote. That excludes online voting. And there is no express provision, whereas, for example, in the UK Companies Act 2006, if the articles permit it, you can vote online. Section 322A, we've referred to in our written case at paragraph 110.
But the articles could otherwise... bylaws could otherwise provide...
The articles or bylaws could
You could have online voting by bylaw.
Yes, you could.
It's not prohibited, but it's not provided for under the...
That's right. And in this case, as I showed you yesterday, the bylaws mirror the provisions of the Act as far as that goes. So moving on then to today's business, could I ask you to look at page 1756? And this is the first of two short points where the learned judge went wrong in the exercise of his discretion by reference to statutory provisions. And 1756 is section 71(1) of the Act. And this concerns some rights given to directors. And a director of a corporation is entitled to receive notice of and to attend and be heard at every meeting of shareholders. Now, we're not concerned with any breach or suggested breach of that. The directors could receive notice of the AGM and they could attend at it. And then two, a director, either who resigns, we're not concerned with that, who receives notice or otherwise learns of a meeting of shareholders called for the purpose of removing him, we're not concerned with that, or C, who receives a notice or otherwise learns of a meeting of directors or shareholders at which another person is to be appointed or elected to fill the office of director, whether because of his resignation or removal or because his term of office has expired or is about to expire, so we are concerned with that, may submit to the corporation a written statement giving the reasons for his resignation or the reasons why he opposes any proposed action or resolution. Corporation shall forthwith send a copy of the statement to the director and to every shareholder. Now, at paragraph 24 of the judgment below, which is on page 22, the learned judge dealt with section 71. He said, I accept that it
Sorry,
does
which
not
paragraph?
state-
I'm awfully sorry.
Paragraph 24, my lord,
20.
page 21, 22 of the judgment. Returning to the language of section 71, I accept it does not state that notice must be given to directors or shareholders where it is proposed to elect another person to the office of director. However, in order to give meaningful effect to section 71, it must be construed to mean that a director whose re-election is to be contested ought to be given some kind of notice. If the director receives no notice, he cannot submit the written statement, which the company cannot send a copy of the statement. The shareholders would not therefore have received full and fair disclosure to make an informed decision on an important company matter. Shareholders surely would be interested in reading what an incumbent director whose position is challenged might have to say about the qualifications and experience of a proposed nominee. Stated above, there was no good reason for failing to give effect to the spirit and intent of section 71, 2 and 3. In my view, the spirit and intent of section 71 was breached, and while the section is silent as to the effect of any non-compliance on the election or the AGM, it's certainly a factor for this court to weigh in deciding whether or not to grant relief. So, the shareholder is not in breach of any obligation by moving a resolution for a replacement director on the floor, but apparently, if they formed a prior intention to do so, as opposed to spontaneously deciding at the meeting that that's what they're going to do, they're in breach of the spirit and intent of section 71, and the court can take that into account in determining whether to give effect to a resolution validly passed. Now, one notes first, of course, the director has notice of the AGM, that's 71.1. And the director knows at the AGM that they might be removed on their term of office expiring, that's the bylaws. The director knows, or must be taken to know, that at the AGM, the resolution for their replacement may be made from the floor, the statute and the bylaws, that requires no notice to be given of a meeting for of a resolution for the election of directors. The director has the right to attend the AGM. In other words, the director, if they attend the AGM, will have exactly the same notice as do shareholders and can engage in the meeting with the shareholders to just the same extent as the shareholders can engage with each other and can make such representations as they choose. And just as with a shareholder who knows that an AGM is being called, a director who knows that an AGM is called must be aware that it is possible that they will be replaced at that meeting and another person will be appointed, of whom the shareholders aren't entitled to notice, and nor is the director. In this case, interestingly, the chairman, Wei Ding-ying, did attend the meeting. He was the person singled out in the Sinovac Biotech letter, and he didn't say anything. Also, one can add that although the Sinovac Biotech letter was not in terms a notice to appoint additional directors or to name additional directors, the company did receive that letter prior to the meeting, and even then, Wei Dong-ying did not seek to answer any of the criticisms that were made in that letter, which he could have done by notice to shareholders prior to the meeting. So, something of an aside, because we're dealing with the legal issue here, really. The second thing to note is that Section 71 gives personal rights to directors. Neither the company nor any shareholder is given any right by Section 71, just as no shareholder is put under any obligation by Section 71. And where the Canadian courts have enforced Section 71, they've done it in personal actions by the directors. So the company refers to Kaiser and Barilla, refers to Olson and River Green, and those were actions where directors complained of a breach of Section 71, and the court reinstated them, made orders reinstating them as directors. Now, if in this case there had been a breach of Section 71, no doubt a director could have made an application accordingly. But there wasn't a breach of Section 71, as the judge found. Given that there was no breach, that a director didn't have a right to reinstatement. And yet, the result of this is that without there being a breach and without the director having applied for reinstatement, the court has given, in effect, the same result. Said, well, you're going to stay as a director because the spirit and intent of this was breached. And
Not quite right to say the judge found there was no breach of Section 71, is it? He inserted by implication an obligation to give notice which hadn't occurred.
he said there was a breach of the spirit and intent.
Yes, but he's implying something into the section.
Yes.
Well, I'm not sure he's implying it into the section. He's implying it into the general obligation of shareholders to give some prior notice.
Well, but that would be nothing to do with the spirit and intent of the section if it was some freestanding general obligation.
Well, that is what he in effect found, this idea of
I
entire...
mean, your main point is he's just wrong to make that implication.
Yes,
Yeah.
yes, he's wrong to make that implication. And whether it's within the section or outside it, Section 71 simply can't, by a side, make that implication. Now, the statute or bylaws could, as they generally do in the UK, provide for a shareholder to give special notice of a resolution to remove a director or to give notice of intention to appoint a director and details of that director's qualifications and so on and so forth, a public company. This statute doesn't, and these bylaws don't. And the implication is impossible because what notice must be given of a proposal? Does this mean that if, at the meeting itself, the shareholders decide to remove a director and replace that person, and they only make that decision for the first time at the meeting, how does that fit in with this idea of spirit and intent? And if there's no obligation, if the resolution is otherwise good at the meeting, because it was only thought of at the meeting, which it must be good, what difference does it make that some shareholder had formed some intention at some point prior to the meeting to replace that director? And who has to give notice? A director, a person who has the intention to move the resolution, a person who has the intention to vote if a resolution is moved. Whose obligation is it? I mean, it must be said on the facts of this case, it wasn't 1Globe that moved the resolution. 1Globe was simply said by the judge to be aware of and acquiescing in the proposal. So whose obligation was it to give notice?
Who, in fact, did move the motion?
I believe it was a company called OrbiMed. So if there is some component in the judge's finding of a requirement to give, as he puts it, information necessary to make an important decision, how does that accord with the ability to make the decision at the meeting itself? The information required is exactly the same. And quite simply, the short answer is the spirit and intent of Section 71 appears from it itself, because it refers to when the director receives notice or when he becomes aware of the proposal. And it may be he becomes aware of it very late. But his protection is that he's entitled to attend the meeting. That's what Section 71 says. You, the director, can attend the meeting, because things happen at meetings. That's the nature of the meeting. The shareholders can consult together. That's what a meeting is. And the protection that the director has there for matters that are raised at the meeting is that he can go armed at the meeting just as much as any other shareholder who comes along to the meeting and finds that an amendment is moved or resolution is made from the floor. The director doesn't have any greater rights, and if he doesn't have any greater rights, how does the other shareholders, how can they have an information right that is inferred from that position?
Section 71 is mainly about directors submitting written statements.
Yes.
Is it common ground that a director who attends a meeting probably has a right to speak at it if his removal is being proposed?
I'm sure that's right, yes.
I think, yes, Section 71(1) says that the director may attend and be heard as a general.
He may be heard. We have put in the corresponding English provisions, which do provide that if a director learns of some business on which he's entitled to give a written notice, he can attend the meeting and ask for a written statement to be read out at the meeting. That's the equivalent. But even in those circumstances, in other words, it may be that something can't be circulated to shareholders. And what it shows really is just the primacy of the meeting. It shows that these things are conducted at the meeting in accordance with the rules.
Just while you're mentioning the UK Act, which is the provision that provides that special notice of a resolution to appoint a director must be given?
Section 169 is the director's right to protest against removal. 168 is the resolution to remove, and special notice is required. We've got this 1829 in your bundle.
Oh, thank you.
1829 and 1830 is the director's right to protest removal. And then the fact that this is an application under Section 122 can make no difference to the analysis, because the discretion can't be excised in a vacuum. If equity regards something as wrongful, so be it. But where there's no equity, then the judge should follow the law. And even if the meeting must be conducted with entire fairness, the fairness is gleaned from the bargain between the shareholders. And the judge simply took no account of that bargain in determining what was entirely fair. You referred to Saul D. Harrison in support of that proposition. I don't think that's likely to be contentious. Now, using Section 122 to create or enforce some abstract notion of entire fairness isn't within the purposes of the section, particularly when the statutory provisions in Antigua themselves provide for what when notice has to be given at all, and that when it does, they expressly provide that the notice must give information sufficient to enable the shareholders to make a decision. So statute has already regulated that issue, what the judge had, this notion of entire fairness. Statute's already regulated that, where notice has to be given. So where the statute doesn't require any notice to be given, there's no lacuna for the common law to step in, for the judge to say, or if you like, say the common law equity to step in and say, well, there's going to be some additional requirement imposed here. even though neither the statute nor the bargain between shareholders requires that to be done. So we say that the court has a wide discretion under 122, but rewriting the statute and the bylaws to require a shareholder to give advance notice of their intention to remove and reappoint directors at the AGM is not within that discretion. My Lords, there's a second point where the learned judge exercised his discretion on an improper basis, and this relates to the proxy form issue. Now, paragraph 30 of the judgment, which is at page 24, the judge sets out the IBC regulations. These are regulations that are made under the Act. It's power to make regulations, and these regulations concern proxies. Form of proxy may confer discretionary authority. With respect to amendments to matters that properly come before the meeting were not identified in the notice of meeting. And then a form of proxy must not confer authority to the board in respect of an auditor or the election of a director unless a bona fide proposed nominee for the appointment or election is named in the form of proxy. And then you'll see at 31 the argument that was put forward by each side. So there was a question that was live before the court below as to whether Regulation 15 had been complied with. And the learned judge at paragraph 36 said this: the court in the final analysis must weigh the right of shareholders to full information, to be able to come to an intelligent decision, against the right of shareholders who voted not to be unfairly disenfranchised. For this reason, I will not make any ruling on the validity of the proxy form, but consider it as a factor in the round when exercising the court's discretion under section 122. So, firstly, we would say that, as with the section 71 point, unless the judge decided that the proxy form was invalid, there was no basis on which to take those provisions into account in the exercise of his discretion. But certainly, when we go to paragraph 46 of the judgment at page 31, the judge says this: when I consider the scale and detail of the secret plan, the absence of full and fair information which deprived shareholders of the opportunity to make an informed and intelligent decision, and the defective proxy forms, so, having decided he's not going to decide, he exercises discretion expressly on the basis that they're defective. Now, just going back, if I may, moving on then to the question of discretion, and going on, if I may, to that issue.
Sorry, are you going to make a positive submission about Regulation 15, one way or the other?
No, I'm not, because firstly, I wasn't given permission to appeal in relation to the section, that issue.
Oh, I see. Okay.
In other words, the findings surrounding that, I wasn't.
Right.
But that doesn't stop me from making the point that I have in terms of the exercise of the judge's discretion,
right,
in the light of the findings he did make in relation to Regulation 15.
So it's an internal inconsistency.
It's an internal inconsistency. Exactly, my lord.
So your position is you're not faced with a finding by the judge or the Court of Appeal that the proxy forms were defective. Is that right?
Well, they said it, because you've seen where the judge said it was defective.
Well, you say it's internally
But
inconsistent.
it's internally inconsistent.
Because he only says it's defective when he's getting to exercise his discretion. So it's what you might call equitably defective or discretionally defective. But,
Yes.
but he doesn't actually decide it when he's dealing with a legal issue.
No, he doesn't.
I'm not quite sure how this all fits together. I mean, if you can attack his exercise of discretion, let's say that you can because of internal inconsistency or whatever, just concentrating on this point, wouldn't that mean that if there is a discretion to be exercised, it's for us? Wouldn't we need to know what the true position was in relation to Regulation 15?
Well, my lords would have to exercise their discretion without having regard to Regulation 15 because no finding has been made and no cross-appeal has been made by the respondents that Regulation 15 was breached. So neither side is saying before you that there was a breach or wasn't a breach of Regulation 15. It simply falls away on the judge's finding.
Right, okay. I'm not sure I follow the logic of that, but anyway, that's your position.
Yes.
Well, just to be clear, I don't accept that there wasn't a finding. There was, and
All right, okay.
that's for later.
My lords, if I can then move on to the question of discretion. The judgment, going back to paragraph 36, where the judge says he won't make a ruling on the validity, we get to this sentence. The court in the final analysis must weigh the right of shareholders to full information to be able to come to an intelligent decision against the right of shareholders to be voted, not to be unfairly disenfranchised. Now, as you'll appreciate, we say that he was weighing something against nothing, because in this case, the right of the shareholders to full information didn't exist. But let's suppose, for the purpose of examining the way in which the judge did exercise his discretion, that that's right. Let's suppose that was the consideration that he was weighing up. Now, if that was a correct statement of the dilemma, then the obvious remedy, which the judge didn't consider, particularly if he was following Kluvac, couldn't have been clearer, was that you can protect both sides of this equation by ordering a new meeting. And at that meeting, the judge would order two things. One is that full information would be given, and that would protect those who hadn't voted. And then he would order that the shareholders at that meeting shall be by reference to the record date of the AGM, and that would protect those who did vote in light of the fact that by the time of the judgment, management had already issued to itself additional shares under the PIPE, the private investment in public equity, which we've referred to in the papers. So in other words, to provide that it was fair to both sides, that's how he could have reconciled exactly that dilemma that he sets out here.
I mean, that sounds like a form of adjournment, but I think you said that no one suggested to the judge that there should be an adjournment.
Not at the hearing, no. No one suggested that at the hearing. Each side was contending for the absolute.
And can I just make sure no one suggested this particular solution at
this
the
particular
hearing?
solution to the judge. But of course, in a sense, it arises on this particular finding, that this is what the judge had found. And when he was exercising his discretion...
Well, so, sorry, just on that, there'd been a full battle before the judge about the defectiveness or other of the proxy form.
Yes,
so it
wasn't
as though people were, this point came out of the blue.
No, neither side suggested it.
No, okay. Yeah, thank you.
So, but the judge identifies this particular dilemma. And so in the exercise of his discretion, he ought to have had regard, at the very least, to the possibility, not least because he had Kluvac before him, which he relied on. He was relying on Kluvac, saying this is what happens in Canada when there is a lack of full information or misinformation. But he didn't go on and say, well, actually, I'm relying on clueback for one purpose, but not for its result.
Yes, but this is adversarial litigation where each party was going for bust, was going for broke, wanting to get their results. No one was asking him to achieve this result. Why do you say he erred in his discretion in not considering it?
Well, my lord, because if the judge is exercising a general discretion, as he was, then that has to be based upon the facts before him, the circumstance of the case. And when we look at the result that he came to, we say that was outside the proper exercise of his discretion.
Well, that's a different point. Your present point is that he should have exercised his discretion and come up with a solution that neither party was wanting.
My lord, if I may, I'm not suggesting that he should have done that at all. What I'm suggesting is that if this was the correct dilemma that was before him, there was an answer. We'll see what he went on to do. But if this was a correct statement of the dilemma, there was an answer to that dilemma.
I see.
Which he could have taken.
But your key point is that it wasn't the dilemma.
Yes. And when we come to discretion, my point is a different one. But I'm simply trying to show that if that was the dilemma, there was an answer.
Yes.
But we'll see what the judge actually did. Instead of dealing with that dilemma, he actually answered the point in a different way. So what he did, having identified that dilemma, he then went on to look at the conduct of the claimant. From paragraph 37 on, page 27. And he goes into the question of what he calls the conduct of the claimant. And he makes the finding that the claimant knew of and acquiesced in the secret plan to take control of the company. That's his finding at the end of paragraph 45 on page 30. And then he goes on at 46. When I consider the scale and detail of the secret plan, the absence of full and fair information, and the defective proxy forms, I'm obliged to conclude this was not conduct that should be rewarded with relief under section 122. And then, at 47, he says this. He refers to Dumont in Manitoba, considering section 139 of the Corporations Act. The court is free to exercise the discretion to make the order it thinks fit. Evidence, the court, paragraph 56, said evidence of wrongdoing and the essential fairness of the electoral process are factors that might influence the exercise of the judicial discretion. I therefore conclude the claimant's knowledge of the secret plan and the unfairness to other shareholders in the exercise of that plan is enough for the court to refuse the relief. So the judge appears to be equating the secret plan and knowledge of the secret plan with wrongdoing. But there's no wrongdoing. There's no wrongdoing at all. Even if everything that the judge found was right, there was no wrongdoing. Shareholders can discuss between themselves prior to a meeting whatever they like.
We have to assume that his factual findings are correct, that you say, so what?
So what? Where's the wrongdoing? What did they do wrong? What did the judge find that they did wrong? He didn't make any finding that justifies the use of the word wrongdoing.
Well, that's because he incorporated the sort of basic level of fairness and disclosure into his concept of what proper or rightful or not wrongful behaviour required.
Yes, because he is assuming that there is, or he has concluded that there is a right to full information.
Yes.
And you say that block, the building block simply isn't
yes.
there.
But if that's right, then all there was the failure to give the information. It can't be additionally wrong. I mean, if the information is required and not given, then and the information is needed, then one gives a remedy based on the lack of information. But to throw in wrongdoing additionally, when actually there has been no breach of the Act, no breach of the bylaws, there is simply no wrongdoing found by the judge. He doesn't identify why that was wrong beyond the mere fact of saying, well, you could have provided this earlier. That's all it comes to.
I think that is probably what he's saying. I mean, the reference to wrongdoing is actually a reference to what the court in the Dumont case said.
Yes.
And he doesn't use wrongdoing in his sentence, I therefore conclude. So I read it, he's rather picking up the second point referred to in Dumont, namely the essential fairness of the electoral process. That's rather as I read it.
If that is right, my lord, then the essential fairness of the electoral process is dealt with sufficiently by referring to the unfairness to other shareholders of the execution of the plan.
Right.
At any rate.
Yeah. I mean, I think it all comes down to having the plan and not disclosing it, isn't that what you're saying?
Yes, which the learned judge disapproved of.
Yes.
But as such, there was nothing for him to disapprove. So, quite simply, the claimant did nothing wrong in law. It did nothing wrong in equity. It did nothing wrong by reference to any understanding or bargain between the shareholders. It has not been fixed with any obligation at all. And the learned judge should have granted the claimant the declaration sought. There was no proper basis not to. And the role of the court, when exercising a discretion in relation to 122, by reference to a shareholder vote, must necessarily be to do as best it can to give effect to the wishes of the shareholders. The wishes of the shareholders, in accordance with their obligations both to the company and to each other, were clear. There was no defect in them. And so we say the judge's exercise of his discretion was flawed. I went through yesterday a series of points in which it was flawed. I've identified, I suggest, 2 other ways in which it was flawed. And in those circumstances, we ask this panel to exercise the statutory discretion afresh and to grant the declaration sought. My lords, unless I can assist you further at this stage, those are my submissions.
Thank you very much.
Mr. Potts.
Lords, just bear with me a second. There's some IT reorganisation. Let me just take me a second.
Would the transcribers want to break in about 45 minutes? Would that be the appropriate time?
I'll try to keep
If you
an
could
eye on
plan on that basis.
11:30. I'm sure I'll be nudged.
Thank you.
My Lords, I will begin by addressing a couple of queries that arose from yesterday during my learned friend's submissions in relation to 2 points. The reference to withhold on the proxy form and the reference to casting votes online. Apart from just trying to get those clear, it's also relevant in order to establish the reasonable expectations of shareholders, and indeed also the business that might properly be transacted on the floor of the AGM. I'll come back to that latter point later. The first is the reference to withhold on the proxy form, and it may just be worth looking at that briefly at page 689. This is in fact the proxy statement which is enclosed with the notice. I hope that your Lordship's version of this is a bit easier to read than mine is, so I apologise if I struggle with it. This point makes it clear that this proxy statement is solicited on behalf of the board, and if one goes down to the middle, where it says underneath voting by proxy, there is there an explanation of the different ways in which proxies can be submitted, depending on whether the shares are held directly or through a broker or nominee, there's a reference to a shareholder being the record holder. So effectively, that's the sort of registered shareholder, is, if you like, the beneficial owner. Or then, where your shares are held of record by a broker, bank, or nominee, which is referred to as street name. So where the legal holder is a broker, bank, or nominee, and that position, in fact, just to make it slightly more complicated, in fact, because there's a US layer, that in fact there is another layer, that in fact the registered holder of the shares, I think maybe in all cases, is Depository Trust Company, because this is a listed company. But we can ignore that layer for voting purposes, because it is the street name who appoints the proxy. And so the point is that is relevant in terms of how a proxy is dealt with, because what will happen is the beneficial owner will pass on an instruction to the broker, bank, or nominee, and they will then submit the proxy accordingly. Now, the judge's findings of fact were not subject to appeal in relation to various matters, such as, for example, the number of shareholders, 3,300 shareholders. They're located in various parts of the world.
You're looking at paragraph 18 now.
My lord, yes. I don't think I need to take you. The points I hope are fairly straightforward.
Well, I may have a question for you about that paragraph, but on we go.
Okay. The shares are listed on NASDAQ, and then it's referenced to the shareholders typically vote online and by proxy in advance of the AGM. Now, I'll come back to this on the advance point. It was said that those who voted online or by proxy card in advance of the AGM would only have known of the incumbent directors. The point is made that in this document, the proxy statement, that if you have the shares in your own name, or you're the record holder, then you can return the proxy card by mailing it to us. But then for street name, where we're talking about the broker, bank, or nominee, there's there a reference to a large number of banks and brokerage firms participating in the Broadridge Investor Communications Services online program. And as I said, that is because they're not the beneficial owners, they're brokers through the shares being traded. And indeed, we can see an example of that, I think at page 978. Now, this is the proxy. I don't think we saw this yesterday. This is the proxy that Mr. Peng-Fei Lee relied upon. And you can see at the top that it's We TD Ameritrade Clearing Inc. appoint Mr. Peng-Fei Lee as proxy to attend the AGM and to vote, including, it says, not limited or to the election of directors. And it's dated the 2nd of February. Just, I guess, one point to note now, of course, is it doesn't refer to any named candidates for appointment. A point I'll come back to. But this is relevant, I think, to a point that my Lord Briggs made yesterday about the difficulty that the proxy holder might have on a mobile phone at the meeting seeking to obtain instruction. It just wouldn't, it's not even possible to do that, because the proxy, in fact, in most cases, and I'll show you the proxy in a moment, in fact, it's the chair who's appointed as the proxy. But even if it was someone else, the question is, who do they phone? Well, the proxy appointer isn't actually going to be in a position to tell them anything of any use at all, because it's the beneficial owner, who's the person who's actually, in the end, to giving the instructions. And that hurdle, we say, is relevant in terms of the reasonable members' expectations. Because what happens is the beneficial owner gives the instruction to the broker, and then the broker gives the instruction and does the proxy. And then the vote, just to be clear, it's not advanced voting. What happens is the proxy is then lodged, but it is lodged in advance. We've seen here it's the second. I'll come on in a moment to that. and the vote is then cast at the meeting by the proxy holder at the meeting. Just to see the proxy forms submitted by the company, we can see, as I said, as to what the usual position is at page 699. Actually, we should see probably the page before to start with, which is the proxy form itself. Again, I'll come back to this. It's not very easy to read, but the relevant page is one turns over the page. You see this is a solicitor proxy in terms of who is appointed as the proxy, and it is the chair of the meeting, is Mr. Yin. But if one turns back to the previous page, what one can see from that, my learned friend accepted this yesterday, that the proxy has to be lodged prior to the meeting. He said that at page 129. And you see here, in fact, in the notes to the proxy, in the box itself, in the middle of that box, there is a note that says, I think, I'm slightly guessing, I think it says they have to be received by February the 2nd.
Yeah.
Yes.
The meeting is to take place on the 6th. In fact, that note also appears in terms that I can't even read on my screen, I'm apologies, but in the top right-hand side, I think there are further references to it being on the 2nd in at least a couple of places, on the internet and so on. And of course, on this proxy form, by contrast with the dissenting shareholders proxy form, you see that the proposed candidates are named individually. And we'll come back to that in relation to it. Firstly, of course, it's consistent with the resolutions that were actually proposed in the notice, which we did look at yesterday, because it was for the re-election. The business that was notified was for the re-election of each of these 5 named individual directors. And here they are individually named, and there is in fact an ability to vote in respect of each of them. So that deals, I hope, with some of the points about proxy forms.
I had a point which I raised, that there doesn't seem to be an opportunity to vote against
Well, this
these
is
directors.
now this is the point I'm about to move on to, which is the about withhold.
Yes.
Yes, that was my second point.
Yes.
So this at page 690, if we could turn to that, which is and you see at the bottom of the page the reference there for proposal 1, the affirmative vote of the majority of the shares cast is required for the re-election of the named individuals. Abstentions will not be counted as a vote for the proposal. Now, I think, as your Lordship explored yesterday, in fact, withholding a vote is treated as a vote against the candidate for re-election. Now, pausing there, I can see some furrowed brows, and it may be possible to understand why. This is again, just to go back to the framework we're dealing with, this is the Antiguan framework, which is based on Canadian, not English law, and the Canadian and US systems of elections, certainly, well, I can deal with Canada, but also the US, and it's North American, is not the same as the UK. I'm going to come on to the statutory framework in the moment. We've already looked at section 71, which is not the same as the English statute, the UK statute. But in terms of that framework, it is important we say in terms of expectations. In North America, there are 2 ways the election of directors can take place, and this is also Canada. There's a plurality system, which is a true election, where votes can be cast for various candidates, and where there are more candidates than places, those with the most votes are elected. The other system is the majority system, which is the one chosen here. That requires that each director must receive a majority of the votes cast in order to be re-elected, and that a withhold is therefore a vote against.
Well, is it? I mean, it's an odd word to use. I mean, if you withhold your vote, have you cast it?
This is the language. It's common language from North American proxy forms.
I see.
And
it's just the other two resolutions have for and against.
yes.
Yes, but the point you're making is if you need a majority of the votes cast,
Yes.
then you are casting your vote to withhold, which is preventing your
A majority
excluding
being
your
granted.
consent from that majority.
Correct.
I just wanted to be clear. I mean, it then goes on to say abstentions will not be counted as a vote for
Yes.
the proposal. Presumably an abstention is not counted at all,
Correct.
because you haven't voted.
Correct.
So shares cast include withheld votes. That's the short answer.
That's the short answer.
Right, thank you.
And it's consistent with the model of elections in North America.
Okay.
And just for completeness, I don't think we did see this. At page 518, just to be clear in terms of how effectively you can sort of, there's a menu of these options. The bylaw 7.8 at page 518, and it is made clear as to which of the systems is to apply here under the bylaws, because it says subject to any rights or restrictions on the shares, you have one vote. All elections for directors shall be decided by majority vote, and then all those others being decided by majority vote except as otherwise required by the Act.
That's pretty straightforward.
It is, but the majority vote is also, it's making clear.
7.8.
It's making clear.
518.
I suppose I was just surprised at the language of withheld in a proxy form, which also includes against.
But not
But
for
anyway, you've
election.
explained the position, and may well be common ground.
You're casting your vote to withhold your vote. It's an odd use of language, but
a bit Lewis Carroll to me.
the outcome is clear.
The outcome was clear, and it may have been, well, clearer to
There we are.
others
Thank you.
than certainly myself as well. Now, having shown the proxy form and the withhold, the relevant statutory and regulatory context, and we say this is relevant to Maloney Friends submissions as to shareholders' expectations in relation to the business that would be, or indeed would and could be conducted from the floor of the meeting itself. My learned friend's position yesterday is that shareholders should have reasonably expected that a resolution or amendment could be put from the floor to appoint new, previously unnotified candidates as directors in place of 4 of the 5 existing directors. And he said, indeed, yes, I quote, the proxies have to go in advance of the meeting. Necessarily, therefore, any business that is raised on the floor of the meeting, of which notice doesn't have to be given beyond the notice in the meeting itself, can be dealt with by those present or those who are there by proxy. Now we say, and I'll develop this ignores the statutory framework, which establishes what business can be properly transacted on the floor of the meeting in the context specifically, it's not general, but in the context of a contested election. Now the danger is, in assuming a UK framework to those provisions, is that in fact this isn't a UK company, and the provisions for elections and so on, which we do not have in our legislation, are different in Canada from the UK, and that's what I'm going to develop now.
Just before we do, I said I was going to raise a point with you about paragraph 18 of the judge's judgment.
Yes.
Because I may have misunderstood it at first reading, but it didn't appear to be consistent with Mr. Chiver's presentation of the legislation. And it's 18.3, where he says, shareholders typically voted online and by proxy in advance of the AGM. Those who voted online or by proxy card in advance of the AGM wouldn't have known. Now, when he says voted online and by proxy,
I think they're not actually different. It's the casting of a proxy, but it's being lodged online.
yes. So really, what he's saying is that it isn't that there were votes other than by proxy
No.
in advance of the meeting.
The point he's making that anybody who exercised a vote by giving a proxy, anybody who gave a proxy would have done so in advance of the meeting, and they would not have known that there was any possibility of alternative candidates. That's the factual finding. And the other point, of course, which I'll come back to, is that he also found that a number of shareholders didn't vote, and he also found that they had no reason to think that anything would be different. But more importantly, that's a more factual finding, but he also found that 23, that in the middle of that paragraph, he said they had no reason to expect, and certainly no idea, that a different slate of candidates would be proposed at the, I think convention means it's the meeting, that they had no reason to anticipate that. And he also said that they didn't have the opportunity to make an informed decision, because indeed anybody who exercised their vote by appointing a proxy in advance would not have known.
But I mean, that doesn't really matter on the facts of this case, does it? Because all those, I take it that all those who lodged proxies in advance voted in favour of the election of the current, of the existing slate.
But it's also...
And there's no one suggesting that they would have changed their mind and voted for the dissident slate if only they'd known the dissident slate was going to be put forward. Isn't the people that matter are those who didn't vote at all?
Well, that's absolutely right.
Yes.
But there is a point. I'll come back to the proxy, those who did vote as well, because it does affect that. But you're right. It's the learned judge does make that point. The point is the absent shareholders. And indeed, we have evidence of that. There was evidence at trial, real-life evidence of this, because a Mr. Leung, who was a shareholder, gave evidence and was not challenged, that had he known what was going on, he would have cast a vote for the incumbent board, but didn't.
Yes, I see. Well, I understand that point. I think it's this focus on those who did put in proxies, which seemed to me beside the point, because the proxy there was entitled not only to vote in favour of the incumbent directors, but was also entitled to vote against the director, those put forward by the other side, as it were.
Well, that's what we'll come on to that in Regulation 15 in
I see.
a moment.
Okay.
So, if I can deal with Section 71 first, just to see that. We did see it this morning, but I think it may be worth just turning up again, if I may. 1756. As my learned friend said, we are dealing with 71(2)(c). Now, the section, as we say, it provides a right in favour of an existing director where he receives a notice or otherwise learns, and I'll come back to that in a moment, at which another person is to be elected in his place, to have a written statement circulated to all shareholders in advance of the meeting, explaining why he opposes that proposal being another person being elected in his place. And then subparagraph 3 deals with the obligation of the corporation to send the statement to all directors and shareholders. There is an equivalent right in relation to meetings called for a removal of the director under 71 sub 2b. B is a little bit closer to the English sections 168 and 169, but it's not in identical terms, and indeed the framework of it is different, because the procedure in England is that someone proposing a resolution to remove a director is required to provide special notice to the company. Now, the policy, we say, behind this is similar, but the way in which it is protected is different. The English provisions just don't address elections at all, but Canada does. And we do say the English policy does also ensure protections for the director and indeed the shareholders. This isn't just for the benefit of the directors, it is for the benefit of shareholders.
In section 71?
Yes, because it ensures that they have the opportunity, and I'll take you to the Canadian cases in a moment, because it ensures that they have the opportunity to consider the representations before.
Well, that's true, but it only operates if the director decides to make representation.
Of course.
I mean, it doesn't provide for any notice to be given to shareholders that other directors are going to be put forward.
That is right. If of course, it gives them the right to consider it if he chooses to produce.
Well, that's right, because it doesn't seem to give a right to shareholders. It's not sort of drafted in those terms.
No, I accept my Lord's point. Now, at trial, the judge held that to give meaningful effect to this provision, that it had to be construed that the director whose re-election was to be contested ought to be given some sort of notice and the opportunity to submit the statement. And it was held that if that was denied, the shareholders were also deprived of information as they are entitled to see the statement. I think that's a slightly better way of putting the point which I just put in my Lord. Now, as my Lords Lord Bridge and Lord Holt said, this is his interpretation. He is interpreting the statute. This is not him saying, oh no, it's all fine, it's being complied with. He's saying it's not, because he's implied...
That's his interpretation of the statute.
Yes. Yeah. And indeed...
The main case you have to meet is that was wrong.
Sorry?
The main case you have to meet is that interpretation was wrong.
Yes.
Yeah.
Well, we say that indeed it isn't wrong, because the court's approach reflected the way in which these identical provisions have been interpreted and applied by the Canadian courts. And the two decisions that my learned friend I think mentioned was Kaiser, it was the first, and we should have a look at that. It's 2732. It's a decision of the Ontario Supreme Court, and one of the questions was whether a director who had been purportedly removed should be declared to be a director. And if we go into the judgment, the relevant paragraphs are only, it's 8 and 9. But firstly, paragraph 8 on it is page 2734, my lords.
2734.
So at the bottom of the page, the learned judge there cited, firstly, identical provisions. It all gets rather confusing because
I don't think we were taken to this case, were we?
No.
We were taken to Kluwer, or however you pronounce it,
We
but
haven't
not
seen
Kaiser.
Kaiser is not Kluwer.
No, but we've not seen Kaiser.
We've not seen it. No, I didn't.
Sorry, I thought you said that
I think he
Chivers had taken us.
No,
but
he mentioned the name, I think.
Oh, I see.
That's right. That is correct.
Just to be clear, Kaiser's a case about the actual removal of a director earlier than he would have otherwise run out of steam.
Kaiser?
Yes.
Yes. Well, it's the point as to... well, yes, I'll show this point here. It's in this
This is
paragraph.
about removal.
Yes.
It's just that here we're concerned, aren't we, with not re-electing a director whose term of office is otherwise going to end,
Yes.
and appointing someone else.
But it's the same... Right. Can I show you, Your Lordship, this, and I'll then answer the point, I think. So, just to frame it, it's the identical provisions that we have Section 71. In fact, in Ontario, just to confuse, because we've got this 122 as well in play, but not the same. So this is the right as to the opportunity to submit a written statement as to why opposing the removal. You're right, but it's the same, of course, the same right is in relation to a replacement proposal. And the provisions were not met. Quite an extreme case, because it was argued that the sole shareholder would have removed Mr. Kaiser regardless of any representations that he made. If he'd made any, he would have removed them anyway. And 9, even though it was said to be likely that Mr. Kaiser would be removed, he was satisfied that Mr. Kaiser should be declared to be a director, and that he was not removed in accordance with the Act. Now, the point on this is that it shows the importance of the protections afforded by the Act in favour of directors, and as I said, maybe not in this case, but also we say more generally, indeed, as regards shareholders, and that the failure to comply with the Act can invalidate the removal itself. And the court here declared that he was a director, I think using the same provision that we're dealing with in our case. Now, we say, indeed, that this, frankly, is sufficient to dispose of our case as well.
Are you going to take us to passages in the judgment?
I'm sorry, my Lord, I was at paragraph 8 and 9.
Yes.
And the point is that it was, even though on the facts that it said it wouldn't make a difference if you had been able to put in a statement.
So sections 122 and 123 of the Business Corporations Act, what did they say?
They are the same as the rights to submit the semester.
Well, same as section 170 of the Antigua Act.
No,
Section 71.
Well, hold on, he was an existing director and it was proposed to remove him.
Yes, and I showed Your Lordship B, where the same right arises in relation to...
Forgive me.
So this was a case where a meeting had been called for the purpose of removing him from office, is that right?
I'm not sure if it's clear quite how they got there, but the fact is that he was a sole shareholder.
It was an interesting case of a sole shareholder and sole director.
Yes, something of a falling out, it might be said.
So the meeting would be a formality, as it were.
I just want to...
But you say, even though the respondent said it didn't matter what Mr. Kaiser said, the shareholder would have removed him. Nonetheless, the court said, you've got to go through the procedure.
Yes, the policy there...
There must have been a meeting, mustn't there, for these sections to apply? I mean, you're telling us that the relevant sections are the same as section 71.
Yes.
So he
that applies.
given notice of the meeting.
Well, that's right. A director who receives a notice or otherwise learns of a meeting of shareholders called for the purpose of removing him from office. So I think we just need to understand here how this operates.
I'm afraid I'm not sure that I can see from the report as to quite how what the procedural steps were, but certainly this section was said to be in play.
But if those two sections are the same as sections 70 and 71,
Which they are.
then the only right which the director had was to be notified of the meeting at which, in fact, he was proposed to be removed.
Well,
that's what I mean, subject to the judge's interpretation.
Well,
there's nothing express that says that he should have had notice of a proposal for his removal where that proposal is made from the floor.
Well, I'll come on to that in the next case.
If we look to the facts at the top of page 2734, what seems to have happened in November 2006, a notice of change of director was filed, but it wasn't clear as to how he'd been removed.
So that's why he wanted disclosure of the minute book.
Yeah, I see, that makes sense.
To see how he had been. Merely stated he was removed. No notice was given of the intention to remove him.
But in all probability, no notice was given of the meeting.
Well, that may be so, although that's not the basis on which the case has been approached. It's on it's been approached, and the judge's reasoning is based on the failure of the opportunity to submit a note, the submission, the statement.
It is, in paragraph 8, it is said, it is conceded by the respondent that the requirements of the Act were not met.
Yes.
So, I mean...
But the provisions that we're dealing with are that they're referring to the provisions of 122 and 123, which is our 71.
71(2)(b), is that right?
Yeah.
That's the relevant bit.
Yes. The relevant, for your Lordship's note, I don't think we need to turn up because I think they are identical. The OBCA is at page 1799.
So 122 is the equivalent of section
71.
And 123 is the equivalent of
122 is 70 and the other one is 71.
That might be it.
Yeah.
Okay. Anyway, there was a clear breach there of the section.
Yes.
Yes.
And as I said, in our case, the judge held that the requirement to give the notice so they could submit statements was not met. Now, my learned friend's case wasn't. He refers to effectively that you need not be concerned as long as there is compliance with the bare bones of the statute. That's his submission. But we say, and the judge has you say so held, that there was not compliance even with the bare bones of the statute. He certainly did not, contrary to the suggestions made by my learned friend, the judge did not hold that the votes, and I quote from his case, they were not, he says that the judge held that the votes were legally passed, is how he puts it in his written case. We say that is not what the judge held at all. He held that there was a breach of Section 71.
When you say the bare bones,
Well, that's
what do you
maybe
mean by
my.
the bare bones?
Well, effectively, if there is compliance with the statutes.
I mean, are you referring to the express terms when you talk about the bare bones,
No,
or do you include
that's my
implied terms as well?
Maybe I'm doing an implied term as well. I have
Okay.
that. But the point is, he says that as long as you comply with the statute, that's the end of the court's inquiry. That is, I think, a fair summary of his submission.
yes.
And the point is, well, even on that case, even on his case, that did not happen. There was not compliance with the statute because Section 71 was not complied with, and the judge has so held.
Because of the implied term. I mean, there was no breach of any express term.
Well, it's the
of 71.
Yeah, well, it's not. I wouldn't call it.
That is what the judge accepted.
Yes, it's not an implied term. I think it's his construction, his interpretation. It's not a contract. It's a statute.
You can have in a statute a necessary implication.
Yes,
can't
it's a
you?
necessary implication of the provision.
Yes.
Yes.
That there was this requirement to give notice.
Yes, I agree. Would accept that.
So it is implied.
Yes.
And we don't know, do we, that the same interpretation was being adopted in this case, because for all we know, this director didn't even have notice of the meeting.
Yes. Well, could we look
But
at?
he almost certainly didn't, because
Could we look
Well,
at?
I think there is
certainly spots that
yeah.
he's been removed from the register of directors and asked, well, how did that happen?
I mean,
This is Mr. Kaiser.
Yes.
Yes. Could we look at another example of this in Olsen, a more recent application of the principles in Kaiser? It's at page 2823, decision of the Ontario Supreme Court from 2022. Just to work out who everyone is. Mr. Olsen, a shareholder director, sought to nullify various resolutions relying on, firstly, the Ontario equivalent of our section 122 of the IBCA, the determination of controversies, and again, we had in section 123 of the OBCA the provisions that we looked at in Kaiser. Now,
see, this was a commercial cannabis business.
indeed, yes, and
One take it must be medicinal cannabis, yes.
Well,
I'm not sure the case
I think Canadian
specifies. It might depend on the date in which
It might, yes,
Section 104, which I'll take you to in a moment, also permits in Canada, again different from England, written resolutions in place of a meeting, except in relation to removal, where a written statement has been submitted by a director. You can see the provision, perhaps it is worth looking at it, 2828. And it's not a written resolution, a unanimous written resolution, but there are various types of written resolution that may take place, may be applied. But expressly provided, except where a written statement is submitted by a director. And then, if one turns to paragraph 22 and 23, just to deal with the fact that in this case,
sorry, 20.
Page 2829,
Right, paragraph 2. Yeah.
paragraph 22,
Yes.
it was submitted that they had no right to be notified of the intention of the majority of the shareholders to pass the resolutions.
And were these resolutions at an AGM? Or?
No, as I said, it's a written
It's a
resolution. It's a written resolution procedure, but subject to 104. And there it said, the submission was that there was no right to be notified of the intention of the directors to pass the written resolutions. And it said, I disagree with the submission specifically on this resolution, which is the removal, and it ignores the language. And then at 24, the judge said, provisions of section 1232 deals with the specific circumstances of resignations or resolutions to remove, and again, of course, we have the same provisions for contested election. It gives the director the right to submit to the corporation a written statement given the reasons for his resignation or the reasons why he or she opposes any proposed action or resolution, as the case may be. That's the same language that we have but for contested elections. The section cannot be utilised by shareholders without regard to 1232, where it involves removal of a director. As it speaks to occasions where a director is about to be removed, we can transfer in about a proposal about to be put to replace him with someone else. It seems to me that any attempt to utilise the provisions to remove the director necessarily requires the director to be given reasonable notice of the intentions of the shareholders. And then he said that at 25, that this is not an onerous requirement, it makes business sense. And this is the policy point that I'll come back to. A director is a significant stakeholder in any corporate structure. They are granted the powers of management, and they're given the ability to address the shareholders in writing. And then perhaps we should go on for completeness to 29. There, Kaiser is cited, which we looked at. And then at 32, he held that under a broad discretion that he had, this is the equivalent of our section 122, he ordered reinstatement. Now, we say, firstly, that's a statement as to the policy behind this provision in terms of what has to be done, but also it's consistent indeed with the judge's approach we say in our case, because just as reasonable advance notification of a proposal is required before shareholders exercise their powers to do a written resolution, we say reasonable advance notice of a proposal that another person be elected in place of the director is required in order to allow the director to have the opportunity to submit a written statement. And that is what is said in paragraph 25. Indeed, in my learned friend's written case, this was accepted, and it was put twice. Paragraph 98, it said the incumbent directors were entitled to submit a written statement to the corporation and to attend and be heard at the meeting. He says, it's paragraph 98 of their written case, or 1666 if you want it, but the point that he then went on to say is, he says they chose to do neither. And again, he said, and then at paragraph 130, he says the incumbent directors had a right to respond to the proposal, but chose not to do so. Now, just to deal with the wording, just because I know about the otherwise learns of that language in the section, all that is doing is making clear that if notice was not given as required appropriately, it does not mean that he does not the right to put in a statement is lost. So the point is that notice is not a precondition to the putting in of the written statement. It's not suggesting, oh well, anything goes. It is only dealing with the point that the giving of the notice is not the precondition to the written statement.
Yes, I mean, there could be a circumstance where someone attempted to give notice, the director didn't receive the notice, nonetheless the director heard through the grapevine that there was an attempt to remove him or her, and a written notice could then be given. The Act facilitated that outcome.
Right.
Yeah.
Just getting back to Olson, if I may. I don't know if you've finished with Olson.
I have.
But section 104 in paragraph 18, which you did refer us to,
yes,
empowers, as I understand it, empowers the shareholders to remove a director by a resolution in writing signed by all the shareholders.
Yes.
But that is expressed to be subject to except where a written statement is submitted by a director under subsection 1232.
Yes.
So in order to make that work, shareholders who are proposing to remove a director by a written resolution will have to give notice to the director. I mean, otherwise section 104 doesn't work.
Well, and it doesn't have to be, in fact, it doesn't have to be all, in fact, under C, I think, it doesn't have to be all the shareholders.
Well, okay, well, a fortiori, if you like.
Yes.
But at any rate, well, the point is that, that section 104 provides that a director can be removed by a resolution in writing, signed by all, or no doubt a majority of shareholders. But that is expressly subject to not applying where a written statement is submitted by a director. Is that right?
Yes, but what the court held here was that in order, again, by implied term, in order to make any sense of that, you have to ensure that the director is given a reasonable opportunity to submit.
Well, I follow that. I do follow that. But all I'm suggesting, I mean, it seems to flow out of, doesn't it, the express words at the start of section 104.1.
Well, it does, but it doesn't deal with the point about the time, what advance notice should be given. That doesn't come from it. It's in order to make sense of this provision, and we say that's exactly the same issue that you're dealing with here in section 71, because my learned friend says, well, we have a right to respond, but we chose not to do so. When I say we, the directors, in our case. Now, that is wrong for two reasons. Firstly, it's wrong factually, because the only director who attended the meeting in person was Mr. Wei Dong Yin, the chairman and CEO, who chaired the meeting. There was evidence before the court, and for Mr. Anderson, at paragraph 9 of his statement, that had he known that there was to be a contested election, two things would have happened. Firstly, he says he would have exercised his right to provide a written statement. And secondly, because he was a shareholder, he also said he would have appointed a proxy to vote his shares in his favour. But he only learnt about the proposal after the meeting. So factually, to say that the directors chose not to submit a statement is factually wrong. But secondly, even if a director had attended at the meeting, they would only have learnt of the proposal and the new candidate at the meeting, by which point there was no opportunity to respond. No opportunity to submit the statement, and no opportunity for shareholders to consider that statement before the vote. So the directors were deprived of the choice to submit the representations by the dissenting shareholders' conduct, as the judge so held, and there is no finding, that factual finding is not subject to appeal. And we say it is also important on what my learned friend says of the reasonable expectations of shareholders as to what business might be transacted on the floor of the meeting. And I'm conscious, and I think that is the moment I was told to hit.
Yes.
If that suits the transcribers, we will adjourn. Is 5 minutes appropriate, or do they wish 10?
They've asked for 5.
5. The board will adjourn for 5 minutes.
So as we've seen, and indeed I'll develop further, the Canadian model emphasises the importance of providing shareholders with the opportunity to consider representations of a director, if made, in relation to a proposal to elect someone in their place, and also the importance of permitting the director the opportunity to make the representations. We also say, as I said, that the representations of that right is only meaningful if the director knows who the replacement candidate is, so that he can address why shareholders should vote for him and not the other candidate. I think it's fair to say that we're all very recently aware that this is the essential character of an election, of a choice between the candidates. And we say that a shareholder cannot be taken to have reasonably anticipated that this statutory requirement would be breached, such that a candidate would instead be proposed from the floor to be elected in place of an existing shareholder. That is because shareholders would reasonably expect that, in line with the statutory scheme under Section 71, the director would have a reasonable opportunity to submit a statement and therefore needs to know what's coming, and that they would have the opportunity to consider that written statement of objection. And we say...
But I mean, how do you square that with the other provisions of both the statute and the bylaws that we were shown, that business at an AGM includes re-election of directors, which seems to import that they might not be re-elected and someone else might be elected in their place?
Well, firstly, this point about the general business, I'll come on to this because there are other provisions as well.
All right.
But we say that the specific takes precedence over the general. And it's not just because it's not about re-election or contested elections. The point is that this is a specific provision dealing with a circumstance. And indeed, in many cases, most cases, the election is indeed entirely routine. It's not contested. And indeed, there are different ways it can be contested. Because there's one thing is contesting an election, saying, you know what, we don't really like the existing board. We're going to withhold. There's another step which is quite different, is to say, actually, we think that Smith is better than Jones, and we want Jones to be replaced by Smith. Section 71, which is our circumstance, and Section 71 deals with that specifically, and it's that specific circumstance. And we say that the point that my learned friend says about he said this morning, well, this just doesn't fit with the decision that was made at the meeting to replace the directors. That's the point. It didn't, because the specific takes precedent over the general. This deals with this specific point and this specific scenario, and that's what you have to do. You have to comply with that. So you can't just look at general business in isolation. You have to look at it in the entirety of the regulatory and statutory context. And I've just given you one piece of it, and there are others to come. Because we say that Section 71, as I say, which doesn't exist in England, forms a part of the statutory framework which is relevant to shareholders' expectations in relation to meetings.
But, I mean, Section 71 does just seem to confer a right on the director. I mean, it says he may submit, he may choose not to. So
Yes.
It doesn't seem designed to protect the information available to shareholders, because they may never get a statement from the director.
Of course, I mean, there is, of course, the obligation on the corporation must forthwith send a copy of the statement.
Yeah, but I'm positing he doesn't make a statement.
Well, that's, of course, in the end, if that's his, if he doesn't. But the point is, it does posit, we say, through the implied term, that he must be afforded the opportunity to do so. And if he is not afforded the opportunity, then that is a breach of the statutory provision.
But do you have to go further and say, and that deprives the shareholders of their right to receive that statement?
Yes, indeed, as well.
But Section 71 is directed to resolutions to remove or not re-elect directors.
Effectively replace, yes.
It
It's to
says
replace.
nothing about proposing a new director.
No, I think it's no, it does. It says that someone is to be elected. That's the point. That's the difference.
Yes.
It doesn't arise. That's exactly the difference. It doesn't arise.
Okay, let me just see then.
If you're just saying, well, actually, I don't like them anymore. I'm going to withhold. Which indeed, that's what we get a sense of that.
Yes,
withhold.
I see.
It's exactly the
It's
point.
C you're talking about there.
Yes.
Yes.
Which is what we're doing.
Yep. Forgive me. Yes, I've got it.
Well, I can see a case for some sort of statutory form of implication if the necessity test was established or
Yes.
satisfied. But in the case which you posit most forcefully of a lot of shareholders having voted by proxy, and then off the floor comes a proposal to not merely not re-elect him, which was always on the cards,
Yes.
but to have somebody else, so what
Yes.
you would call a contested election
Yes.
situation. Why, and a director says, well, I want to be heard about this, to which the obvious answer is, well, how will all those proxy voters be heard? Why isn't the obvious solution that the chairman will just adjourn the meeting?
Well, the first point is that the chairman doesn't have a power by himself to adjourn. It requires, I think, the members to vote
But it
for
depends
it.
on the rules or the bylaws.
I don't
or the Act says.
believe. I don't believe that he's not provided with the power to.
Why can't the meeting just get adjourned
Well, I mean,
by whatever techniques available?
yes, I mean, at common law, a chairman has a power to adjourn, I think, a meeting.
It's not in every.
Not in every circumstance.
Certainly not in every circumstance,
No, I see.
and not in this. It may be on Bing if it was. I don't believe there is a power provided. We'll have a look at that, but I don't believe it is the
Right.
case. But as I said, we say it's also, and I'll come on. There are more authorities to come, I fear,
Right.
and more provisions. And I'm going to take my Lord Briggs's point on in terms of proxies in a moment. So we say it is the overlay, and let's look at what happened here. In this case, the dissenting shareholders didn't give any notice of their secret plan. We haven't gone into. There's a whole series of factual findings about the secret plan and the relevant. Mr. Lee gave evidence at the trial and was wholly disbelieved in relation to a lot of his evidence. As to whether there was a secret plan, and the judge made significant findings in relation to that effect. And the reason why they didn't give notice, precisely because they didn't control the majority of the shares. Through secrecy and withholding information from shareholders, they were hoping to ensure that those shareholders would not exercise their votes in favour of the incumbent board and against the alternate slate. And we have evidence of shareholders who that exactly worked, including even one of the directors themselves who didn't vote.
Well, it's very sorry to interrupt my learned friend. If my learned friend is relying on any finding of the judge to make those submissions, that was the reason, then it would be helpful if he could take us to.
No, I'm not. But the point is, we say that this is the antithesis of shareholder democracy. But we do say that the breaches of Section 751 were sufficient reasons to refuse relief. I'm going to move on to Regulation 15 of the IBC regulations. My learned friend didn't take you to some of the findings, I think, in the judgment. It's page 25. And then I'll show you. Actually, perhaps no. Maybe let me start by showing you the regulation itself. Let me start firstly with the statute, section 351 of the Act at 1765. This is the statute itself, and section 351 provides that the Commission can recommend regulations as required for the better administration of this Act. So for the better administration of the Act, the regulations are made. Again, the regulation itself is at 1850. At the top of the page 15, it stated a form of proxy must not confer authority to vote in respect of the election of a director unless a bona fide proposed nominee for the appointment or election is named in the form of proxy. Now, if one turns to the judgment at page 25, the learned judge made findings here. The objective intent of 15 is unmistakable. It's to ensure, on important matters such as the election of directors, the will of the shareholder, the proxy giver, is effected, and that all shareholders have been provided with full information concerning the election of directors.
I'm sorry, which paragraph?
Paragraph 32, my lord.
32.
Page 25.
Oh, sorry, thank you.
Apologise. Right. I take that again. At the top of 32, the object and intent of Regulation 15 clear and unmistakable to ensure on important matters such as the appointment of the election of directors, the will of the shareholder, the proxy giver is effected. That's one point. And that all shareholders have been provided with full information concerning the election of directors. And then he makes a point about Mr. Peng Fei Lee, which I'll come back to. But then at 33, he says, at the bottom of the page, right at the bottom, his finding is, I'm of the view that the defect was not waived by the company. So he again, clear reference to that it is defective. Now, 2 points to make. The first is that there is no appeal against these findings. There was an appeal, and the appeal was refused, and permission to appeal was refused. So these findings are final. That's the first point. The second point, again, is these provisions are, again, these are Canadian provisions. This is the Canadian model. And there is no equivalent, as far as I'm aware, nothing even close under the English statutory regime. Let me show you the proxy form again from the dissenting shareholders at page 978.
978.
978.
Thank you.
And you see here that this form of proxy used by the dissenting shareholders did not name any nominees for election.
Yeah.
The learned judge also held and noted that Mr. Lee, Mr. Peng Fei Lee, who was appointed as a proxy by 1Globe on this document, was himself nominated to be a director at the meeting by someone else, and his evidence was that he had no idea that he was going to be nominated at the meeting. It's the end of paragraph 32.
Sorry, page.
In the judgment. The judge held that the forms were therefore not compliant. So it follows from his own evidence that he's saying not only just the non-compliance, but in fact that he hadn't been authorised by the proxy giver in relation to his own appointment. And as I said, the judge's findings, not subject to appeal, were that the object and intent of the provision was firstly to ensure that the will of the proxy giver was given effect to, and also that all shareholders were provided with full information concerning the election. Because how can a shareholder name a nominee if they don't know who is going to be put forward? And it is clear from the finding that the proxy giver must specify the name of the candidate or candidates that the proxy giver is directing the proxy holder to exercise a vote on. Now, the learned judge did consider Canadian authority. Just to see some context, slightly different, but page 2212, but he is ambassador at the start of the report, and we'll deal with just to the fact pattern. And I'm going to say make the point that you're going to see we are seeing quite a lot of cases here with dissident shareholders providing information circulars in relation to contested elections. And I'm going to be developing a point that that's not an accident. But if one turns up, please, that's the fact pattern, 2227. Now, in this case, we can see the provisions at the top. They're slightly different in terms of where...
Here?
I'm sorry, my lord? Page 2227.
What's this we're looking at?
Now, this is the relevant provision of the legislation that they were dealing with.
Well,
this is
ambassador industry.
This is ambassador. This is within, I'm so sorry, my lord. I took you to the front page and then didn't tell you where I was taking you next. I apologise. This is within the judgment of ambassador. As I said, the context was that the dissident shareholders had, indeed each side had provided an information circular in the form of proxy for a contested election, but each side naming their own candidates. Now, the provision at 2227 deals with the relevant provisions here. And this one is slightly different if we look at the top, because again we have the point about no proxy shall confer authority to vote for the election of a person as director, but there it's not actually got to be in the proxy form itself, but it's got to be in the information circular sent to the main members. But it's the same, we're in the same territory. And in the middle, the judge said that, well, in considering whether they'd done what done in regard to the manner in which the proxy had been drawn, namely their own slate, each side having their own slate, no room for any others, whether I have to consider each side's circulars. These made it very clear to all concerned who is running and whether that candidate is part of the management slate or the dissident slate. And then at the bottom of the page, he said, I find that in deciding whether or not this proxy is valid, the test I have to apply is whether under the circumstances of the information circulars sent out by the petitioner to each side's circulars, it said there's sufficient information to conclude that a shareholder is in a position to come to an intelligent decision as to whether he should vote for or against the directors on their respective slates. So just pausing there, first point is that he's making the question he's asking about is judging the integrity of the decision making at the meeting, which is the point that we see in Thiessen and in Kluwak. And in that case, he was satisfied that there was everybody knew what they were doing, effectively. They knew what they were voting for, because...
They obviously knew the names of the rival candidates for election. That wasn't an issue. I assume what was an issue was whether each of the circulars was fair and so on. I mean... No, my lord, no. The issue was whether they had been effective, because they didn't name all of the candidates. They only named the ones that they were voting for, they were casting the votes for, which is the requirement in D. Because he says these make very clear to all concerned who's running and whether that candidate is part of the management slate.
Yes, so it's clear that whoever signed, whichever proxy they signed, it was clear that they had named the person that they were voting for, and they understood who they were voting for when you looked at the two together.
Okay. There are two issues here, aren't there? One is whether Regulation 15 was complied with or not.
And the judge so held it wasn't.
Well, the judge certainly set out the facts. There's a dispute between you as to whether he, at the end of the day, did or didn't resolve the question as to whether that was non-compliance with the regulation, but put it in on discretion.
Yeah.
But the second question is, if it wasn't complied with, what are the consequences of non-compliance? In other words, who can complain about it? Is it just the proxy giver whose proxy holder has voted for somebody who the proxy giver didn't know about, and or is it void for all purposes on the application of anybody who's a shareholder or a director or the company or anybody else? But it doesn't follow as night follows day that non-compliance with some regulatory requirement makes the proxy void.
No. Well, I'm going to come to that point right now.
Okay, that's fine.
But it's, if I may, I'll take it in a slightly different order, if I may.
By all means,
Because
but
I think there is a
I just
different...
want to keep those 2 points.
Absolutely. There is a
conceptually separate.
Indeed. The point I'm making is it goes particularly, well, an additional point, is that this goes to the expectations of shareholders. And let me, if I may try and develop...
I haven't got that out of Ambassador and Camfrey.
Well, no,
I'm not quite clear what point you're making, because there was an express... we've seen the requirement at the top of page 16 of
Yes.
section 181. So no proxy shall confer authority to vote unless the nominee is named in an information circular. Okay, so that's clear.
Yes. I'll go back to the regulation, if I may, and
Yes,
explain that.
is there anything we get out of Ambassador and Camfrey?
Beyond that point in terms of
All right.
it deals with the, and particularly it also deals with the approach in relation to what the court is concerned about, is the test which I refer to in page 2228 at the top,
Yeah,
about the intelligence.
Okay, well,
Yeah.
I'll look at the case.
We say that this goes to the expectations, and indeed the judge so held, that it was required, that people would be expected to comply with these proxy provisions, because it ensures, firstly, that the proxy holder has been authorised, and it also ensures that it cannot be said, it's a statutory requirement, but it also meant two other points. As I said, Mr. Lee himself accepted that he hadn't been authorised by his own proxy giver. Secondly, we say that if it had been complied with, it would at least have provided some advance warning of the proposal to elect the alternate slate.
Yes, I was going to ask you, at what was the deadline for submission of proxies? Before,
2nd of February.
so 4 days before the...
Yes.
Yes. So what you're saying is you have to read Regulation 15 and Section 71 as
Together.
part of
A package.
a statutory package. And if Regulation 15 had been complied with, then the company and the directors would have at least 4 days' notice
Yes.
that something relevant was about to happen.
Yes. It's in fact, it's more than that. It's not a lot of notice because, in fact, as I'm going to come on to, the point is, though, it also meant that the shareholders themselves, by the non-compliance, were deprived of advance warning of the proposal. And I say that does fit in.
Well, hold on a minute. We're looking mainly at the non-voting shareholders.
Yes. Well, no, I think I'm going...
All right, but let's look at them to start with.
Yeah.
And asking whether Regulation 15 creates an expectation that they will know before they decide not to vote who any proposed alternative directors are going to be. But a mere regulation that requires other people who put in proxy forms to tell the company who they're proposing to vote doesn't of itself, does it, track through to the non-voting shareholder?
Well, the first point is you can't look at it separately from Section 71. That the mechanism, the policy is to ensure that this advance notification is given.
Yeah.
We say it fits in with that. And the point is, yes, firstly, if you're going to decide I'm not going to vote, the fact that no advance notification, the proxies are not being able to do it. But the point is actually, what's the expectation about on the floor of the meeting? The point is also that on the floor of the meeting, if the point is proposed on the floor of the meeting and we have someone, a proxy holder is holding a proxy, they will not be able to cast a vote on that resolution.
Certainly.
Because So it's actually even members present at the meeting by proxy.
Unless the meeting gets adjourned.
Well, why not? Sorry, those present.
But not in person,
or
by proxy. Present by proxy.
Why couldn't they vote on it?
Because the regulation requires the named candidate, the person who they vote for, to be named in the proxy. And if you don't know who's going to be on the slate at the meeting, you can't give the authority hence the point about my nominees and so on in advance. You've got no idea, and you're not able to cast a vote on the proxy.
I mean, that's what leads me back to ask myself, well, who can complain about that not being on?
Well, my question, if I may, can I put the question another way, which is because I say that deals with the members' reasonable expectations as to what business would be conducted on the floor of the meeting.
You keep saying it goes to their reasonable expectations. I'm just trying to see how that argument works. Is this an argument that when construing the notice of the AGM and the items of business listed there, that you have to read that through the eyes of, I don't know, a reasonable shareholder with the reasonable expectations that you keep talking about? And how would they understand?
It's not so much about the notice. It's the expectation as to, and I'll come on to this as to what could have happened, indeed what happens in Canadian cases, is that the expectation is as to what could happen at the meeting itself. Because, for example, I can put in my proxy. I've got to decide: am I going to put in my proxy before the meeting?
But isn't that a function of what a notice says?
It's in part of the notice, but it's also the question is: what is your expectation when you receive the notice as to what business will be conducted on the floor of the meeting?
Right. So that's. I mean, tell me if I'm wrong. That seems to be an argument about the interpretation of the notice of the AGM in this context that you're emphasising.
It is certainly in part in relation to the notice of the AGM, but also in terms of what is a valid amendment, what can be proposed as what would you understand as a valid amendment to a resolution, or a valid resolution that could be put on the floor of the meeting.
All right, yeah, thank you.
And
I'm having difficulty with your interpretation of Regulation 15. The form of proxy sent out by the company did confer authority to vote in respect of 5 named individuals.
yes,
If someone proposes that others should be appointed in place of those 5,
yes.
I don't understand why the company's proxy doesn't permit the proxy to vote against that resolution, which is, in a sense, a wrecking resolution or amendment to the resolution on which he does have authority to vote.
If he has,
It says it must not confer authority to vote in respect of the election of a director unless a bona fide proposed nominee is named in the form of proxy. I mean, it would be a bizarre result to say that where you've got the sort of proxy form we've got in this case, sent out by the company, that proxy can't vote against what is a wrecking resolution or wrecking amendment to the re-election of the existing directors. So I question whether Regulation 15 has the effect which you're suggesting or submitting that it does have.
well, is it worth also looking, and we haven't shown Regulation 14, perhaps I should look at that as well, and, to see where we are then. 1849, I think, is where so we looked at 1850, which is 50.
So we should 18.
Just to place us at the top of it, page.
14,
so 1850 is Regulation 15, which we saw.
Yes.
And then the immediate regulation before is that a form of proxy may confer discretionary authority in respect of amendments to matters that properly come before the meeting and that were not identified in the notice of meeting. But then we have the specific. That's quite general. And then 15 is specific.
But, I mean, you don't need to expressly confer authority on the proxy on amendments in order to enable the proxy to vote against a wrecking amendment. Because it necessarily follows from an authority to vote in favour of a resolution that you have authority to vote against a wrecking amendment. I think there's plenty of authority on that.
I see that. The point is, when we've seen the proxy form that we have here,
Yes.
but in terms of those who are at the meeting with a proxy,
Yes.
and may not have already voted in favour of the existing directors,
Well,
what do they
I
do?
don't know how this was done, but was an amendment proposed to substitute the dissident slate?
Yes.
Well, that's a wrecking amendment. So
Yes.
why can't the proxy holders of proxies sent out by the company, why can't they vote against that wrecking amendment?
But the question is also, there's 2 points. First, the point is, well, first, let me just deal with the points in turn.
Okay.
The first point is, just to deal with 14 and 15, is that 14 deals with discretionary authority in relation to amendments that may become properly before the meeting. But then you have to read it, that's the general, but then you have the specific of Regulation 15, which expressly provides that the proxy form must not confer authority in respect of the election of a director unless there is the bona fide named nominee for appointment is named in the form of proxy. So we say, firstly, that distinguishes between the ability to confer a discretionary authority on amendments, which is for certain matters, but on 15, where you're dealing with the nominee for election, the vote may not be cast unless it is named, the nominee is named.
And you say that the holders of proxies in the form which had been sent out by the company
Yes.
could not vote against the amendment proposed by the dissidents.
They
Is that what you're saying?
they couldn't vote
In respect of that amendment.
in respect of the amendment or the
That, I
resolution.
think, is, if I may respectfully say so, an extraordinary consequence of your reading of Regulation 15.
But I thought your main point wasn't anything to do with the proxy form sent out by the company.
No, it's not.
It's to do with the proxy form
point is,
sent out.
So you're accepting that the form sent out by the company,
Oh, yes.
those proxies could vote
Yes,
against,
absolutely.
could
I'm
vote
sorry.
against
the amendment.
amendment.
Yes, I think, yes.
Yes, I see. No, I understand. Oh, I see. Well, I understand the point you're making about the proxy form sent out by either dissidents or dissenters. Oh, yes. Well,
Yes.
yeah.
I'm sorry,
I'm sorry.
I was at cross
we were at
purposes.
cross purposes.
We were. I apologise.
Yes, because if you read Regulation 15, it is directed at a proxy in favour of the election of a particular nominee.
Correct.
No, I follow that.
And it says nothing about a proxy conferring authority to vote against that nominee.
Exactly.
I mean, I don't know quite. Yes, I see. So right. Okay.
Yeah.
I'm not quite sure where we get to from this, though. Regulation 15.
Well, the point is,
Your point is simply that the proxies that voted in favour of the dissident nominees were invalid.
correct.
Yeah.
Yes.
Well, but that's
my first.
I mean, I understand that, but that's, as I understand it, the point the judge didn't rule on.
No.
And he didn't address the arguments that were put, because the claimant submitted that Regulation 15 applied only to proxy forms issued by or on behalf of the company. He didn't rule on that argument, as I understand it, or did he?
Yes.
I don't think he addressed it, did he?
We'll check. I think he may have done. Well, I'll consider that.
I mean, I don't quite know how we deal with his closing words and saying he wasn't ruling on it.
No, I mean, we have the facts, and we know that a sufficient number of proxy forms put in for the dissenters
Yes.
didn't specify the identity
Correct.
of the directors.
Correct.
But the judge hasn't ruled on whether, as a matter of law, that invalidated those proxies.
Yes. Well, we say it is a basis for invalidating, and that's the first point. And the second point is, it goes to the expectations, because the point is that you would not, as a shareholder, you would therefore not expect someone to be proposed from the floor, because you would not be able to, even if you wanted to vote in favour, if you didn't know about it.
Unless I keep boringly come back to the point that if that surprising event occurred, you might expect that the meeting would be adjourned.
Well, but it doesn't. We say that is, but we say it's part of the provisions of the
It's sort
advance
of part of the mosaic.
The mosaic.
I see, yes.
And could we look at one of the proxies relied on by the dissentants?
Yes, I
just
did.
so can
I
see
showed you,
We saw one earlier, yeah.
but I can go back to it.
978.
Just,
978.
978.
978, yes.
Ah, right. Yeah, thank you.
can I just ask this on proxy forms? Is there anything in the Act which requires proxy forms, or the regulations, which requires proxy forms to be lodged before the meeting or at any particular time before the meeting?
I don't believe there is.
So it would be open to a company to permit proxy forms to be lodged at the meeting?
Yes.
Yes.
But the but is I've referred to the chain of command, if you like,
Yes.
in terms of how that would work. Because the point is, and we would say this is on the expectation, is that even if you're at the meeting, or you wouldn't be able to, because if you're outside of the meeting and forget the chain of command,
You're not there.
you're not there. You've got no idea, and
You're separated by your street broker.
and you're separated from your indeed.
Yes. I suppose I was asking it in relation to I think the submission you were making, that Regulation 15 is sort of part of a scheme which enables at least some notice to be given to the company of different directors who may be
Yes.
proposed.
And the scheme that I say it's not just some notice, it is the Section 71 notice, it's the reasonable notice to allow the submission of the statement by the director in the contested election, because having seen that statement and seen what the contending options are, a proxy, a shareholder is therefore able to execute a proxy form in compliance with Regulation 15. And indeed, that is what we'll see. We've seen already a couple of examples of that. That is precisely what happens in the Canadian cases, that you have a proxy battle with each side putting forward their views and their candidates and soliciting and submitting proxy forms in compliance with the Regulation 15 procedure to vote for their alternative candidates. But it all fits together and it works. And it also fits with the Canadian authorities, which we've cited in the bundle, and I may, subject to patience, show a couple more of those. But the point is there is full of judicial statements emphasising the importance of these contested elections and that shareholders should be properly and fully informed before making their choices. And this also, of course, it provides a protection for the existing directors, of course, but it also provides, if you like, a protection for the integrity of the decision-making process, including, in particular, as your Lordship said, my Lord Richards, about the absent shareholders, because they can then say, well, okay, I've seen it, I'm going to put in a proxy, or I'm not going to bother to put in a proxy, or indeed, I can change my proxy, because there is also a power to change one's proxy.
I follow all of that, but I'm then slightly puzzled why you're so resistant to there being a power in the chairman to adjourn the meeting, because some of these things might blow up at the meeting.
Yes.
And then I would have thought that the arguments in favour of shareholder democracy, everyone being informed about what the issues are that they're voting on, would point in favour of, well, let's pause things now, adjourn so that everyone can take stock and then resume the meeting.
Yes. Well, of course, the first point is that certainly isn't, well, I can't say there's a fact, you can make a factual finding about this, but we say the whole point of the secrecy was to ensure that there wasn't democracy and an informed decision. Otherwise, why else would you not give advance notification?
That might mean that, I mean, Mr. Chivers takes umbrage at that, but
I'm sure.
Even supposing that was their objective, what I'm putting to you is that's not the objective of the company. The company's objective should be to allow democracy.
It didn't happen, and
Your submission isn't just geared to a reasonable shareholder expectation that others who wanted to get together and suggest somebody else would do so in advance and provide advance notice.
Yes.
Yours is geared to seeking to establish that, contrary to the what you might call at first blush impression, that the actors and the regs, the bylaws have clearly made appointment directors non-special business.
Yes.
It can be done from the floor.
Yes.
And the Gordian, not as my Lord Sales is suggesting, it's not that it can't be done from the floor, whether by as the implementation of a prior ambush or not, but that if it is done from the floor, there'll probably have to be an adjournment.
Yes, of course, neither side contended for that. Indeed, the relief that was...
That doesn't
the relief
give
that
away the legal
no, the relief was...
interpretation of all these supposed implied terms.
No, but the aim, we say, of the advance notification requirements is to ensure that, and indeed as a matter of exercise of discretion, fresh elections indeed have been ordered in some of the Canadian cases, suggesting that that may be a solution. I'll come on to discretion in a moment. I mean, the fact is it just wasn't posited as an option, so the judge chose between the two that he had.
I mean, if we're bandying around implied terms, I'm not sure why the better implied term, if you need one, is a power to adjourn, to give effect to all these informational provisions that you emphasise.
I would say that the shareholders, I would say that wouldn't be necessarily their reasonable expectation, because they would say, viewed together, this, and indeed the way the proxy contests usually work in Canada, and I'll come on to yet further, I'm afraid, the SEC regulations which go into this expectation point, and my Lord's point, Lord Sales's point, because we say that, in fact, the answer is that you give advance notice in advance of the meeting to ensure that these steps can be taken, reasonable notice. And I showed your lordships the early case about you have to give advance reasonable notice to the directors so they can put in.
But that seems to be in conflict with the provisions we've looked at that seem to suggest that these matters can be raised at the meeting. That's the fact that it's not special business of an AGM that you have re-election of directors. They may not be re-elected. Obviously, they may not be.
Yes, but here we have the specific, which we say takes precedence over the general. And the point about general business is you have to read what general business is in the context of the specific.
But except that the Act says all business is special, except.
Yes.
And then you have a series of exceptions.
Yes, but
one of which is this one.
Well, it's not, because we say the election of directions is maybe ordinary business, but a contested election to replace engages the specific provisions of Section 71, and also we say Regulation 15, which sits with it.
But I thought by the bylaws there had to be one director.
Yes.
So why isn't it necessarily implicit in the business of an AGM where the election of directors comes up and they may all be voted down,
yes,
that you have to find another director,
well,
and that must be part of the business of that meeting?
Well, no, because I'll come on to this in bets, because in fact what happens, the Act in Canada is different from the one in bets, because what happens is, well, we have 2 points. We have my Lord Hodges' point about, well, if you're not removed, then you carry on, that provision which we looked at yesterday. But we also have the further provision is that, in fact, if there are no directors, what happens is that you don't have someone different from bets, is that it's not proposed at the meeting itself. It's expressly provided that there is then a special meeting called for the election of directors. So the statutory framework, again, is different than England.
We haven't looked there.
No, we haven't, because I was going to do it when I go with
all right. Fair enough.
I'm sure I haven't forgotten.
No, you certainly haven't, my Lord.
We better let you develop your sense.
But if I may, otherwise I will also forget where I was as well. I'll come back to that. Regulation 15, if I may, I'm going to move on from to the NASDAQ. Another expectation, which again the judge so held, is that members were aware, obviously, of course, aware of the fact that the shares were listed on NASDAQ. Now, shareholders were therefore subject to disclosure and filing requirements under the US security laws. And we dealt with this in our written case. These are designed to ensure that investors have adequate advance information to make informed, rational decisions. Now, Mr. Chivers indicated that because it's a listed company, in fact, there are no obligations or expectations that can arise. We say that that's incorrect and in any event isn't really the right question. The question, as we've talked about, is would shareholders have the reasonable shareholder have the expectation as to what expectation would they have as to the business that could properly be conducted on the floor of the meeting? Now, in any event, if one looking at construing articles and so on, it's public knowledge that the company is listed on NASDAQ, and of course all the shareholders know that, and also that the shareholders are subject to the US security laws because these are US listed shares. And we say that there is a reasonable expectation, shareholders will have reasonable expectations that the shareholders will comply with those security laws. As I said, and it goes to the business expectations as to the business that might be conducted on the floor. Now, the rules, in fact, are best explained by the order made by the SEC against...
Can I just ask this?
Yeah.
Are you suggesting that there was a breach of those rules?
2 points. Firstly, that there was a breach, yes, and I'm going to show Your Lordship the finding of the SEC.
Yeah.
But secondly, it's also relevant because it goes to the main point of as to what the expectations are of shareholders.
The expectation is presumably that the relevant securities laws will be complied with.
Yes.
So unless they were not complied with, it doesn't give rise to any expectation.
Right. Well,
but I'm sorry about it, but paragraph 59 of the judgment at first instance.
Could Your Lordship give me the page?
Yes, it's page 36.
59. Yes. The judge didn't make such a finding, I accept.
He said it's a matter for the US court.
Yes.
And so he won't make any findings.
No.
So have the US courts made any findings?
Yes.
I see.
Securities SEC. Well, the SEC. So the SEC has levied a fine. I'm going to show Your Lordship that now.
I see. So
this isn't.
This is not relied on below, was it?
Not relied on at trial.
No.
Presumably it happened after the trial.
Well, the point was relied on as to and indeed I rely on it, is as to the expectations of shareholders.
No, I understand that.
I understand that too.
The concrete question,
Yes.
was there a breach of the security laws, wasn't resolved at trial.
No, it wasn't.
Was the SEC decision that there was a breach before or after the trial?
It was after the trial.
After the trial?
Yeah.
Was it raised in the Court of Appeal?
No.
Right.
Was it before the Court of Appeal hearing?
May I just take instructions on timing? I don't want to get this wrong. I think yes, this is on. No, the answer, my Lord, no.
Sorry, what?
No, so it wasn't. I think it was
Wasn't
after.
raised in the Court of Appeal. But you
wasn't
also
raised.
asked whether it happened before the
Oh,
Court.
I think it happened after the Court of Appeal, I think.
Okay.
Before judgment. Before judgment.
Before judgment in the Court of
Thank you.
Appeal. So it could have been put before the Court of Appeal.
Yes.
Yes.
You say this is a new point in this court.
Well, the point is, no, the point is, the point was raised as the expectations of shareholders in relation to what would happen and how other shareholders would behave in relation to raising business. If I could show, maybe if I show you the regulation.
Absolutely. I just wanted to be clear what the status of this was.
Yes.
Show us the SEC decision, De Beni essay.
Yes. My Lords, I'm not asking Your Lordship to make a finding that there was a breach.
Oh, I thought you were.
No. Well, I'm sorry. I'm just going to show you what the findings of the SEC statement was. But my point is as to the expectations of shareholders, given what the regulations were, which we can take because it's explained what the requirements are in this decision.
Right.
So I'm going to show Your Lordship the decision. The order is at page 3963. And then at 3964 is the summary of the findings.
My Lords, I'm very sorry to interrupt, before my learned friend goes to that, I think it's important that you do read item 2 on page 3963.
Yes, that is a fair. I'm grateful. That's fair. But could I look at the paragraph 1 at 3964? So just the context, the multiple violations of 13D of the Exchange Act and rules by 1Globe Capital and Mr. Lee's company he owns, and then the requirement. It requires a person, including a group who directly acquires beneficial ownership of more than 5%, to file a statement with the Commission within 10 days, disclosing information relating to such beneficial ownership. It's a key regulatory provision that allows shareholders and potential investors to evaluate substantial shareholdings and the implications for their own investment in the security. Whenever a material change occurs, then a new filing must be promptly amended. So the filing must be amended. And then paragraph 2, the parties held nearly 1/3 participated in an activist plan to replace 4 or 5 directors through a vote, but failed to disclose material information required under Schedule 13D, and that participation in the plan led by other investors thereby deprived existing and potential shareholders of information necessary to make fully informed investment decisions. And then, if one moves on to paragraph 10, again, that also then deals with the further details about the requirements. Disclosure about details as to the identity, amount held, and then description of the purposes of the acquisition. And of course, remember, we're talking about also changes, including any plans to affect the board of directors. And that includes 5, description of all contracts, arrangements, understandings, or relationships with respect to the securities, including giving or withholding of proxies. So, and 11, the obligation is to promptly amend a filing where there's a material change of the facts reported. And then at paragraphs 27 to 33, which I don't think I need to take yours, it's all the way through, but it effectively sets out details of the events that led up to this AGM, much of which formed the subject matter of the judge's findings of fact about the secret plan, which are not subject of appeal. And then the violations at paragraph 34 at 3971, and in particular, over the page at E, it said that the failure to file a Schedule 13D by no later than the 22nd of January, disclosing their participation in an effort to replace 4 of the 5 incumbent directors through a shareholder vote, thereby violating the Act and the rule. And then the consequences at 3973 at B and C is a fine of $200,000 against 1Globe and $90,000 against Mr. Lee personally. Now, the context, and as regards shareholders' expectations, is that, firstly, this framework is intended to ensure that shareholders are provided with advanced information so they can make informed investment decisions. Now, of course, that requires returns, and then shareholders, of course, are then notified of the position as per the return. And again, given this expectation, the requirements to provide such advanced disclosure, this again meant that there would be, shareholders would have an expectation of advanced disclosure of an intention to propose a new slate of directors to replace the existing board. And again, that is part of the framework and context with which we judge reasonable shareholder expectations in the context of what business would be anticipated to be conducted at the meeting. And we say that it is part and it's consistent with that entire framework, which is of advance notification, so that shareholders can make informed decisions, which is a point which is also part of the mechanism with Section 71. And this is all, of course, I mean, with Canada and the US, there's a lot of overlap in terms of the approach. It's a North American approach. But they fit together in relation to the change of the proposal to change the board is a key question. And the policy is that shareholders should be fully informed about such a proposal to replace the board. And indeed, this leads to the mechanism, Section 71, Regulation 15.
What is this shareholder expectation trade in aid for? Is it for construction of the IBCA, or is it for construction of this company's articles and bylaws? And if it's for either of those, when was the company first listed on NASDAQ? And has it changed its articles and bylaws since? Because it would be odd if the bylaws and articles and the Act meant one thing before it was listed and something different after it was listed.
Well, firstly, I do pray and aid that it is consistent. The first point is, I say it's consistent with the reasonable expectations of shareholders of this company as to the scope of the business, their expectation as to what business would be conducted on the floor of the meeting. That's the key point, we say.
Yes.
I mean, that seems to be, putting back to you what I asked you before, interpretation of the notice of the meeting. What does that item comprehend may happen?
Yes, and we say it doesn't comprehend an amendment on the floor to propose new candidates.
But going back to my Lord's question, he asked, what is the shareholder expectation prayed in aid for? On that way of putting it, as I understand it, you're saying it's prayed in aid for interpretation of the notice of the meeting.
Yes, and
rather than for legislation.
Yes, and we say it's consistent with the policy of the statute, but it is also the main point is as to what the expectation of shareholders would be as to what would be happening at the meeting.
But then, can I then ask my Lord's question again? If one takes the IBCA or the bylaws, in what sense are you relying on these reasonable expectations, as you put it, for their interpretation? And if so,
I can't rely on the SEC in relation to the statute as a whole, because of course I accept that not every IBCA company is listed on NASDAQ. Yeah. But even in that regard, I would say it is important to remember that the IBCA, any IBCA corporation, this is legislation which is designed for companies that conduct their business and affairs outside of Antigua. They are for international companies. Yeah. So it's many of those companies, of course, will be US and North America facing. But not exclusive. I can't say that exclusive.
Of which some will be listed.
And some, indeed.
Yes.
Yeah.
So if you seem now to be saying the IBCA is geared to catch a cohort of companies, some of which will be NASDAQ listed.
Yes.
So if that's right, why can't you pray and aid this NASDAQ background for interpretation of the IBCA? Well,
indeed, I accept. As I said, that's why I mentioned the IBCA. I think it is a part.
Right. I'm just trying to
see. I can't say that it applies to every.
It's rather odd, though, isn't it, that this act in Antigua should be interpreted by reference to listing rules applicable in a particular jurisdiction, the United States, and would one actually be looking at those listing rules from time to time, or at the time when the ICBA was enacted? It might be a bit more plausible to suggest that the bylaws which are company specific, might be interpreted in light of listing rules applicable to them, but it's quite a stretch, isn't it, to say the ICBA should be interpreted in the light of the what happened to be the US securities law.
Because talking about capturing a cohort of companies from different jurisdictions, it'll capture from other jurisdictions which have different rules.
And many may not be listed.
Yes, indeed. I'd say that.
Yeah, I see.
687.
But just to be clear, is what you are saying, if we go then to the bylaws, what do you say is the relevance of the NASDAQ listing for the interpretation of the bylaws? Perhaps you don't make any specific submission about
No, it's not. No, it's on the notice. It's the specific of this case. It's the context and the interpretation of the notice and the reasonable expectations of shareholders.
It's really focused on the notice.
Yes.
The AGM is at page 687. I'm being asked to, as it were, interpret this notice in the light of those submissions,
Yes.
which is cast in somewhat torrential language, one might say. The annual general meeting will also transact any other business as may properly come before it, or any adjournments or postponements of the annual meeting. So it expressly contemplates, as part and parcel of what may be appropriate business, that the meeting could be adjourned or postponed. That's page 687,
Yes, I see
about a
that.
third of the way down the notice.
Yes, I see that.
But you would say, I suspect, that the words "any other business as may properly come before it"
Yes, and of course,
has to be interpreted in the light of, among other things,
NASDAQ.
the NASDAQ listing.
yes, and also in terms of the adjournment question, of course, it's the question as to how such an adjournment might happen. Indeed, whether it could just be done by the decision of the chairman, or whether actually the members at the meeting. It would depend on the members at the meeting putting a resolution to adjourn. Which, of course, in our case, unlikely to happen given the proxy. Assuming the validity of the proxies, but if they were valid, then that might not be happening.
Yes, thank you.
So, in terms of now the factual findings, I should turn to next. Your Lordship's obviously have seen the judgment, but we say that this is interesting in relation. There are factual findings which we've outlined in our written case, and we say that if one looks at bets, the judge in our case, applying the principles of bets, made effectively findings which are diametrically the opposite to those which were found in bets, which he, of course, he expressly considered. But the key findings of the judge in our case are to the effect that a reasonable shareholder would not have considered the proposed election of the alternate slates on the floor of the meeting to be competent business for the meeting to conduct. And secondly, he also found that the absence of full and fair information in fact deprives shareholders of the opportunity to make an informed and intelligent decision.
So, where does he make these findings? Just for our notes.
These are, we've got, it's paragraphs 18, 23, 46.
18, 23 and
46
46.
together. Now, a learned friend made suggestions yesterday about certain red flags that the court should take into account.
Sorry, just taking, you say you found that it not to be competent business for the floor of the meeting, and that there was an absence of full and fair.
Let me just.
Well, my question was, as I understand the submission that you were just making about how one interprets the notice of the AGM, it's almost as though, in the absence of full and fair information, one would not expect business to be moved on the floor of the meeting.
In relation to this particular issue?
Yes.
That's right.
So those 2 points, they're not completely separate. They, on your submission, as I understand it, they sort of hang together in that way.
Yes.
Is that fair?
Exactly, but he says that is exactly it, and he said, particularly at 23, that they had a finding which there is no appeal against. They had no reason or warning to expect anything different. Certainly, no idea that a different slate of candidates would have been proposed at the meeting.
He's there talking about shareholders who voted online in advance.
Yes.
No, it says they, as well as those who chose not to vote, did not have the opportunity to make an informed decision. So he's dealing with both.
But we've obviously looked in some detail
Yes.
at the judge's reasoning behind those inferences which he draws, none of which included non-compliance with NASDAQ listing regulations.
Well, the issue of the context as to the NASDAQ rules was run before the judge.
Yes, but he doesn't pick them up, as far as I can see.
He doesn't make a ruling as to whether there was a breach. But
No. What I mean is, he doesn't include the constraints imposed upon shareholders in a NASDAQ-listed company as affecting his perception of what ought to be inferred as to reasonable expectation.
He does refer to the SEC requirements,
I'm sorry, I missed it.
and he as being a matter which was raised because submissions were made to the judge on that.
Where do we see that?
I just had a quick look through those 3 paragraphs and didn't find it.
20 yes, 21.3 refers to listing on NASDAQ regulated by US securities law.
I think you find a reference in paragraph 6, 4, that this was one of the grounds of the company's defence of the proceedings. But I think that it's then dealt with ultimately in paragraph 59.
Yes,
But as you say, at that stage, the SEC hadn't ruled.
they hadn't. But the issue was, as to the points were made as
The points were made,
as to the
but they didn't play any part in the judge's decision because there had been no ruling. We couldn't help him unless there had been a breach of the rules.
Well, no, my lord, the submissions were made as to the expectation that as to what is it that the rule requires, and that what would be expected of shareholders, therefore, what they would do, i.e., that they would provide advance notification of a concert party to change the board.
This is, as we know, expectation is, if I may put it this way, a slightly weaselly word. Are you talking about rights? Aren't we talking about rights and duties and obligations here? I mean, you are putting it in terms of rights, aren't you? You're saying that implicitly, under Section 71, shareholders were entitled to be told.
Under Section 71...
Not as an expectation.
No, 71, yes.
Yes. But are you saying there's some other basis?
Well, and I also pray and aid Regulation 15 as well.
Yes.
I mean, I think that the judge does seem positively to rely on the NASDAQ regulations in paragraph 21.3. That seems to feed into
bets, yes.
and seems to feed into the NASDAQ listing as part of the picture, seems to feed into, and therefore had no notion that an entirely different slate from that on which they voted would have materialised at the AGM.
Oh, Lord, yes.
Yes, indeed.
And as I said, I don't believe there's an appeal against that finding.
So that's not so much based on any SEC ruling of breach.
No.
It's what the rules say.
Correct.
Prospectively, that's
Correct.
what people expect
And that is my
will
point.
happen.
Yes,
And that would determine such business as may properly come before the meeting.
correct.
Yes.
And you just referred to the SEC ruling afterwards to say, and lo and behold, there was a...
Well, yeah, but I'm I hesitate. Perhaps it might be called a jury point, but I'm actually the point I rely on the ruling for is for what it shows. It shows you what the requirement is in a neat way.
Yeah, because they say the requirement is this, and then they say, and it happens to have been breached.
It happens to
You're
be. I'm not
relying on the first bit.
I'm relying on the first point, not the second.
Yes,
And my learned friend rightly makes the point about whether it's some sort of plea bargain or whatever. But the rules set out very clearly from the Commission. I think they know what their own rules provide. And indeed, we say that shareholders are to be expected to know about their obligations to comply with those rules. So we say, I was talking about some red flags, my learned friend, in terms of red flags. There's a couple of those I need to deal with. As I said, the first one is, well, we have the the findings, which I've referred to your lordships to. And as I said, we also said the point which that was partly as an answer to the Betts point, because the factual findings was which stand were the opposite to those in Betts. I'm going to come on to those. And the second finding, which is not in Betts, goes to the exercise of discretion in relation to the declining relief because of the application of the established principles in Thiessen and the other authorities about the depriving of shareholders of making an informed and intelligent decision, which the judge made findings of. And as I said, just to recap in terms of the special business versus ordinary business point, Section 109, it is right that, of course, there is this distinction of special and ordinary business. It didn't actually make its way into the bundle. And I accept, however, that, of course, that there is a distinction between the two. But we say that the court will protect the absent shareholder. And it's not right to say that the fact that there's a reference to ordinary and special business fundamentally undermines that principle, because we say you have to look, the specific overrides the general, and when you look at the reference to general business, you don't stop there. One has to go on and look at the regulatory and factual context, and indeed the terms of the notice itself. And it is worth, I've made the points already in terms of what the notice actually said, in terms of it was re-election, named candidates, and so on. We say that even the amendment of an ordinary resolution is the case, the textbooks, for example, Gower says that an amendment to an ordinary resolution is, as to whether it's permissible, it is permissible if no member who had made up his mind whether or not to attend and vote, and importantly, if he had decided to do so, how he should vote, could reasonably adopt a different attitude to the amended resolution. That's at page 454. And I'm going to comment on to inductor in a moment.
That's Gower at 12027.
Yes.
And they go on to comment about Mr. Justice Slade's judgment in Moorgate Mercantile.
Indeed, I'm going to come back.
You're coming to that?
Yes.
Yes, okay.
I'm sorry, and what was the bundle reference for the Gower?
Sorry,
I thought you said 454.
454. No, I'm sorry, that's a wrong. 4381. That's a terrible reference, even by my standards.
4381. Okay, thank you.
Another way of putting it is, of course, that I'll come on to the Gupta, another Canadian case, says it's in the best interest of shareholders that they make fully informed decisions regarding the election of directors. And we say that these amendments did operate to the prejudice of shareholders, and that their expectation was that a resolution to replace the board would not occur on the floor, with them having no knowledge of the individuals proposed or their qualifications, no receipt of a statement from the directors, and indeed no ability to exercise a voter's proxy in relation to, for example, to vote for them. If you can't vote for the amendment on the floor because of Regulation 15, how can that be competent business for the meeting? So just to
that's a matter of hard law rather than expectation.
Yes.
Yes.
Well, indeed.
You have been picked up by
Lord
Richards for relying on reasonable
I won't use the E word.
What I think your submission comes to is that the combination of Regulation 15, Section 71 and NASDAQ regulations meant this could not be done
Yes.
as a matter of law.
Yes. And shareholders would not expect it. Well,
do you need that?
Maybe I don't. But both, I'd say both. I'm going to still hold the belt and braces on it.
Yes, I mean, in a sense, this very thing couldn't be done, I think
No.
you say.
Yeah.
The proposal could have been mounted, but with proper notice, and then you
Yes.
could have had proxy forms which identified directors to be voted for in accordance with Regulation 15, and everyone would know what they were doing.
Yes, exactly. And just two red flags about this. My learned friend's written case says it wasn't ordinary times for the company and refers to the two different offers. Well, I mean, the judge obviously was fully aware of that. I am just concerned to ensure that this cannot be viewed as, and should not be, an impermissible collateral attack on the judge's findings as to expectations of shareholders have been given notice. That is not open to my learned friend. Given the findings that have been made, which are not subject to appeal. Now, there was an attempt to appeal on facts, and that was refused. Also, the Sinovac Biotech letter, which my learned friend, I think, in writing referred to as a wake-up notice, and I think is also mentioned at least a couple of times before your lordships. We addressed this at paragraph 113 of our case. Again, the judge made factual findings in relation to that letter. Again, the findings are not subject to appeal. It's right, of course, that Sinovac Biotech wasn't even a shareholder and not able to propose business at the meeting. The letter was not sent to shareholders. It was published on Newswire, and there was evidence from shareholders, Mr. Leong, that he certainly hadn't seen it. And also, most fundamentally, the letter did not give any indication that alternative candidates were going to be proposed for election in place of the current board. There were some criticisms of the board made, or certain members of the board, but no indication of alternative, of a plan, or indeed the secret plan, to propose candidates on the floor of the meeting. So we say we have Section 71, Regulation 15, the SEC rules, and so on. And I've made my submissions on that. Now, my learned friend's position is he says there's no room for any minimum standards of fairness, and the court indeed has no right to intervene beyond checking, that his case was, that beyond checking that the provisions of the statute have been complied with. Now, my first point, and my Lord Hodges' point to me just now, is, of course, that we say there wasn't compliance with the statutory regime, not least Section 71 and Regulation 15. And so we say that even on 1Globe's own case, the court was justified in refusing relief. We also do say that the cases do say that, about what the standard of fairness is. Now, again, we say the starting point should be Canada. We have CLUAC, which my learned friend says in his written case was doubtful as an authority. The first point just to make is that it's not considered, certainly isn't considered doubtful in Canada. It's been repeatedly cited without criticism, and we've given the references to that at paragraph 136. 2738 is the decision itself. Let's see if I think I may be able to deal with it before break. Just in terms of the fact pattern, the contested election between management and dissenting shareholders, a theme which may be increasingly familiar.
This is a case about a misleading circular.
It is.
Yes.
It is. And indeed, there was rival circulars, and it was agreed, the court agreed with the chairman that the dissenting proxy circular was misleading, and they exercised a discretion to order a fresh election. And indeed, you're right, of course, my lord, the question about misleading statements, and one sees this at paragraph 14. But the point was made there in relation to explanatory statements, of course, that they must be perfectly fair and give all information reasonably necessary to enable the recipients to determine how to vote. And the point is, it goes for dissenters as well as the board, and that shareholders must have all the information they need to make an informed decision about voting. And then there's also paragraph 16 about plain and fair disclosure. And then paragraph 30, there's a reference to Blair, the Supreme Court of Canada, and the point there in relation to the actions of the chair there in that case, that it gave all the shareholders an opportunity to make a fully informed decision regarding the election of the directors, thereby promoting the integrity of the voting procedures. So it's a reference in the Supreme Court about the importance and the integrity of voting, of the voting procedure in relation to the election.
Which paragraph was that?
I'm sorry, my lord. It is paragraph 30 on page 2743. There's the points made in the facts of the case, but this point was about the question of disallowing the proxies.
Well, that seems almost like the adjournment point.
It is. I see that. But the point I take it from in terms of the...
So just Blair.
Yeah, no, yes.
Blair, I mean, I haven't read Blair, but just reading this, it looks like row blows up at the meeting. Everyone needs to have information to decide how they want to vote in relation to the matter that's subject to the row.
Well, in fact, a new meeting.
But they don't deal with the business there and then.
No,
they have a new meeting.
But it's a new meeting, exactly. Not an adjournment, but a new meeting.
Well, is that functionally different from an adjournment? I mean, they didn't. It looks as though they didn't deal with the business at
no,
the
but
meeting.
the point is,
If it's an AGM, you probably have to do it by adjournment because of the directors running out of steam at the AGM and things like that.
except they continue.
Well, subject to what that continuation point
Yes, it does. It does what it says on the tin. Come on to that.
Yes. Anyway, in one way or another, it seems in Blair, what the chairman did was create a pause for proper information to be distributed.
Indeed. But we say that's the proper expectation. And the point I make on this also is because my learned friend says that there is no there's no effectively his case in his other than defamation, shareholders can say what they like, is what he says in his written case. And we suggest that this suggests that that is not so, because in terms of the point is it may be looking at it at the wrong end of the telescope. It's not the duty on the shareholder. It's the point is, does it affect the integrity of the decision making at the meeting?
But Mr. Chivers takes the point on this case that this was a case where the dissenting shareholders chose to speak. They issued their circular, and I mean, one can readily understand that if you choose to speak, you have to do so fairly and not deceptively.
Yes.
I mean, Mr. Chivers distinguished it by saying there isn't a duty to speak on the dissenting shareholders, and if they're just silent and they go into the meeting.
Well, of course, we've dealt with that.
But then it just seems to come back to what the shareholders are on fair notice of what they should expect at the
exactly.
meeting.
The point is, my telescope point is, one doesn't look at that, there's a fiduciary duty. It's not the issue about whether there's a fiduciary duty on the directors or indeed some duty on the shareholders and what they say. The question is, it's at the other end that the issue is as to whether it's right that the members can be said to be properly bound by a vote at that meeting in circumstances where maybe there are, indeed, how do you bind the absent shareholders? What are the circumstances in which you can bind an absent shareholder?
You say that all goes back to a proper understanding of the meaning of the notice of the AGM.
Yes, but also, yes, the answer is yes. But the point is, in what circumstances can the absent shareholder be bound? Yes, and in our case we say... Well,
because if they're fairly notified that
this is coming,
then they take the risk.
Yeah, absolutely, but this is not that case.
Can I just raise a point on paragraph 14 of this case, where the judge begins with a quotation from a book called Shareholder Remedies in Canada, which is expressed in very general terms, but is there any, I mean, we haven't got that book, I think, in the authorities. Is there any suggestion that actually that is saying any more than is then said in the rest of this judgment?
I'm afraid I'm unable to say.
Oh, thank you.
And indeed, I've overrun. Yes.